feel it's very important to take this concept of estate planning down from the pedestal it sits on and offer it to the masses in an easy and affordable manner. In this chapter, I'll be taking you through the basics of estate planning, where you'll learn a few general concepts like what is an estate plan, why is it important to create one and how to get started, what are the tools available to help create an estate plan, as well as a few common myths that I would like to bust, because much unlike a bad rumor, misconceptions about this topic have caused innumerable family feuds, financial losses and hardship for families in India. Now, what exactly is an estate plan? Let's first talk about what wealth journey for any individual will look like. It first starts with wealth creation, which can come from your primary source of income, be it salary or business income. Then once you start accumulating savings and building a corpus for yourself, you might want to start to look into how to build a passive income stream for yourself. You can do this by managing and growing your wealth through investments in capital markets, insurance, saving schemes, rental property purchases, and so on. All these steps help you build assets for your family. Now, I don't need to dive deep into more specifics here because the few steps I just outlined for wealth creation and management is something us Indians know well. We all aspire to earn more, live better, save, build assets, etc. Why am I even talking about this, right? Well, there's a reason. What happens to all the assets, accounts, and wealth accumulation once you pass away? The financial journey of any individual does not stop at wealth creation and wealth management. Most of us often get stuck at this point, but the journey is only complete when you plan for wealth protection. In order to do this, you need an effective estate plan that will not only ensure complete access to your hard-earned assets during your lifetime, but it will also ensure that your assets go to your loved ones in a seamless manner after your lifetime. More importantly, if something were to happen to you tomorrow, you can rest easy knowing that you protected your hard-earned money and assets by creating a simple plan. And that's your estate plan. It ensures that you are in control of your assets in your lifetime and provides an instructional guide for your next of kin that will be followed by law in the event of your passing. Now let's get into why you even need an estate plan. The primary reason is to ensure that your assets and belongings are distributed according to your wishes when you're not around. Without an estate plan, your assets can be subject to legal disputes, hefty taxes and family disagreements, as we learned in the last chapter where I spoke about few public cases. In India, today approximately 1,50,000 crores is lying unclaimed in financial accounts. This does not even include unclaimed real estate assets. So why has this happened? It's a simple answer: because families don't know these accounts exist. And when you don't know whether something exists or not, you won't do anything about it, right? Now let me also give you another statistic. Of this 1,50,000 crores, approximately 30,000 crores was recently transferred to the RBI after some accounts were remaining unclaimed for more than 10 years. This tells us two things. One is that eventually people's hard-earned, tax-paid money goes back into the hands of the government. And two, without more awareness and discussion about the importance of estate planning and why you need it, this number will continue to grow. So coming back to why do you need an estate plan? It gives clarity to those who survive you. Clarity in terms of 1, what assets exist, 2, clarity in terms of where these assets lie and how to find them, and 3, clarity about who the assets go to. This can be to family, friends, or even charity. It's safe to say that an estate plan is a form of financial hygiene that, if looked into properly, can save your family from hassles and stress. It can also save them from unnecessary cost and time, which without a plan can accumulate over at least 3 years from my experience and with the cases that we have dealt with at Yellow. Bottom line, you need an estate plan because your family should not suffer from financial losses when dealing with their grief. Now, by this point, I've explained to you what an estate plan is and why you need one. Mind you, this chapter is more of an overview and we will be going more in depth into how to create your estate plan depending on your situation and what you want from it. But for now, I'll briefly explain how it works and what your options are. The first thing you want to do is to think about your family situation and what objectives you have for yourself and for them. By family situation, I mean taking stock of each family member. What are their genders, their ages, where do they live, is anyone a minor, How financially sound are they, and so on. There might even be a circumstance where you need to plan ahead and ensure continuity of something for when you are not around. For example, care and finances for a specially abled family member, or education expenses, etc. With regard to objectives, we all have similar ones, like providing for our dependents or ensuring proper distribution of your assets. But you could also have objectives from asset distribution, asset protection, to charitable giving, to minimizing taxes and costs for your next generation, to even medical needs and even requirements in the event that you are incapacitated, and so on. Your objectives are personal to you and your family situation, and depending on what those objectives are is how you actually decide on what tool you need to make your own estate plan. At this point, professionals like myself and Yellow can come in and address your specific requirements, answer your questions, and understand your objectives. That way, you can decide which tool best suits your requirement. The two tools typically opted for any estate plan are wills and trust. We believe a will is a must for everyone and something that should have been done as of yesterday. If your objectives are not fully met through a will, then you can explore trust as a tool for your estate plan. A will, which is also referred to as last will and testament, is a legal document that outlines who you are, what are your assets, and how these assets needs to be distributed when you are not around. What's interesting and important to note is that a will is one of the only documents you can use to appoint a guardian for your minor children. Without one, it is the court who decides and appoints a guardian. I've seen young parents pass away during COVID, leaving both sides of the family fight for custody of your minor children. This is another reason that a will should be your baseline for estate planning, regardless of what other tools you decide to use. Like I mentioned earlier, when your objectives are a bit more complicated and are not fully met with a will alone, then you should also look into trust structure, which is a separate legal entity that holds assets for the benefit of you and your beneficiaries. And the rules and instructions are set by you during your lifetime and will continue to be in effect post your lifetime as well. Don't worry, we will go more in depth into both trust and will later on in this masterclass. Now, there are a few other tools that I should mention that can help protect your interest, but again, choosing the right one depends on your objectives. Let's look at something basic that most of us already do and should do for every asset: nomination. Now, what is nomination? Who is a nominee, and how does this play in your estate planning? Nomination means specifying a person called as a nominee to act as trustee or a custodian of an asset in the event that the owner of the asset is no longer available. While technically this is not an estate planning tool, in conjunction with a will, it's super effective for smoother and quicker transmission of assets from a deceased person to the rightful beneficiaries. Does that mean a nominee is a beneficiary of an asset? No, not necessarily. A nominee, as I just mentioned, is a custodian or a trustee of an asset. Let's take an example of a bank account. In the absence of a will, if the bank account owner passes away, the financial institution can transfer the funds to the nominee as the custodian of that asset. The nominee's role then comes into play by distributing the assets equally among the legal heirs. In many situations, people choose their nominee thinking that this person will be the beneficial owner or the only beneficiary of that asset. However, this legally is incorrect. This is why we say this is an estate planning tool in conjunction with a will. It is important to align your will with your nomination to avoid ambiguity and make processes quicker and smoother. Moving on to the next tool, which we sometimes recommend based on the client situation, is called a gift deed. It's a legal document used in India to transfer ownership of certain assets or properties from one person to another within his or her lifetime and without any consideration. Gifting is a common way to give properties and assets to family members, friends, or other individuals, but it should be used very cautiously. Why? A prime example is the Singhania's case that we touched upon in the last chapter. Feel free to refer back to the previous chapter at any point. Now, gifting is very clean and efficient in terms of seamless transfer of assets to loved ones. But be very mindful of it and make sure you're never in a position where you're not in control of your assets or finances within your lifetime. This is especially important for senior citizens. as an estate planner and representative of Yellow, we always advise our clients not to do this unless it is to gift a small portion of your assets for a specific events like marriages or birthdays, or if the circumstances of your life warrant you to do so. Another estate planning tool is a joint account. It is not a tool in a literal sense, but like nomination, it is something that helps in smoother and faster transmission of assets. How? The surviving account holder will gain access to the account and can even operate the account. I do want to mention though that there are multiple kinds of joint accounts. There is a regular joint account, either or survivor, former or later, and more. And the rules are different for each of these accounts. For example, a plain joint account has the same rules as a joint holder in a property, which is that the survivor is eligible only to 50% of the assets. Similarly, each type of joint account has its own set of rules. And similar to a nominee, the survivor is not automatically entitled to be the legal owner of the entire account. The survivor may get access to the assets, but ultimately it depends on the facts of how the account was set up, that is, who funded the account or how the account was reported, so on and so forth. Just as with nomination, if you have a will that aligns with who the joint account holders are, then all questions gets sorted out easily. So now that you're aware of the tools available to you when considering your estate plan, I'd like to talk about few misconceptions out there that might cause a roadblock for some people who wish to start their estate planning journey. 1. I just touched upon this earlier, nomination in joint accounts. Most people think that with this in place, they don't need a will. However, legally speaking, this could not be further from the truth. I just went through the basics of joint account, so I'll spare you a repeat. But I do think it's worth talking about the role of the nominee again. A nominee is a mere custodian of an asset, with a few exceptions like in the case of insurance and PF, where the nominee actually becomes the beneficial owner. What this means is that in the absence of a will, the nominee is obligated to take the asset in question and distribute it among the legal heirs. In India, legal heirs are defined only in two ways. 1. The beneficiaries as per your will, and 2. In the absence of a will, a legal heir is defined by your personal law on the basis of religion or gender. So for example, for a Hindu male, in the absence of a will, his mother, spouse and children are regarded as equal beneficiaries of his assets. So moving on to the next myth, estate planning is only for senior citizens or if you're extremely unwell. Here's a fact for you. Anyone above the age of 18 can create an estate plan. At Yellow, we like to push our clients and their children to get to this important task sooner rather than later. Because you never know what the future holds. Life is as uncertain and unpredictable as it gets. I mean, we went through COVID, right? And lost many friends and family members along the way. Uncertainty and unpreparedness comes hand in hand, and it's a slippery slope that leads to a number of questions for surviving family members in the event of your demise. Unlike in my 20s, the access to information and technology today makes it easier for younger people to earn and invest privately. So if you do not make note of this information somewhere, how are your next of kin to know how and where to access this? Now let's look at number 3. Estate planning is only for the wealthy. At the start of this masterclass, I mentioned that there is a staggering amount of money lying unclaimed. This number is 1,50,000 crores, and with time and no planning, this pool of money will only grow. I said that the majority of this money was not accumulated from the wealthy, but from middle class people like you and me. More importantly, let's look at the situation where you might be the sole breadwinner for your family. What if your spouse isn't up to date or aware of what assets you hold? A clearly defined will can help your family seamlessly gain access to your assets. Number 4 is that you need a lawyer to draft your will, and once made, it cannot be changed. Absolutely not. There's no requirement or law that says that a lawyer needs to draft your will. In fact, with Yellow, you can write your will from the comfort of your own home. More on this in a later chapter. There are even case laws where a farmer had written his will on the bonnet of his tractor and it was considered valid. But more importantly, you can amend your will as many times as you wish. We even recommend checking your will at least once in a year in the same way you do your taxes. If there are no changes both in your asset as well as family situations, at least you have the peace of mind that your will is fully up to date. Number 5. A will must be on a stamp paper, notarized or registered. Again, this is a gross myth which makes the process seem extremely complicated and daunting. A will can be written on a simple A4 piece of paper. It will be considered valid as long as you sign it along with 2 witnesses. Notarization of stamp paper is not required and in my personal opinion provides no added value. Registration on the other hand, though not mandatory, is an optional step, and I would like to point out that registration can be helpful when real estate is involved as it makes the whole transfer process easier for your family. But more on that later. Moving on to number 6. All assets automatically go to one spouse, so there is no need for a will. This statement is simply not true, and it's a misconception that gives people an easy reason to not write their own will. I briefly touched upon this when I spoke about nominees and the concept of legal heirs. Without a will, Indian succession law kicks in, which is what determines who your legal heirs are. So if your wish is that your asset needs to go to your spouse or to any specific individual, then there's no other way to make this happen other than through a will. Number 7, this is a very common myth. If I make a will, then I lose control of all my assets. The best part about a will is that it comes into effect only upon your demise, not before. Therefore, whatever assets are in your name will remain in your control until your demise. And finally, number 8. A will is time consuming and costly to make. This is part of the reason why we started Yellow. In the past, this may have been true, but now with platforms like Yellow, you can create your will from the comfort of your own home with access to legal experts. The best part is that we don't burn a hole in your pocket. We have made the whole process of making an estate plan accessible and affordable for every Indian. In this chapter, I took you through the basics of estate planning, some tools available, and more importantly, we busted few myths together. So now I hope you are ready to get going on your estate planning journey, starting with a will. The next chapter will be all about wills, from what is a will to various components that make it whole. Welcome back to Yellow's masterclass on estate planning. In our previous chapter, we laid the groundwork for understanding what estate planning means and why it's so critical. In this chapter, we'll explore what a will is, including what it covers and what it doesn't. We will also clarify common misconceptions and guide you through the key elements involved in making your robust will, such as naming a beneficiary, how to choose your executor, and appointing a guardian for your minor children. Then we will also talk about the consequences of dying intestate, that is, without a will, and how that can complicate the distribution of your assets to your family. And finally, as a special bonus, stay tuned until the end of this chapter. I'll be sharing expert tips and insider advice that you won't want to miss. These tips can help you avoid common pitfalls and ensure your will is as strong as it can be. By the end of this chapter, I'm very confident that you will have a clear understanding of why a will is the foundation of any robust estate plan and how to go about creating yours to ensure that your wishes are fully honored. So let's get started. What is a will? When you hear the word will, you might picture a dusty document, something that comes only into play when someone is old and seriously ill, right? Let's challenge that notion right away. A will is actually far more dynamic. It's a very powerful legal document unlike any other that lays out your wishes for how your property should be distributed and who should take care of your minor children after you're gone. It's your voice, your instructions, and your final say on what should happen to your assets and responsibilities when you're no longer around. Simply put, a will isn't just a piece of plain paper, it's a plan that protects your loved ones from the chaos and confusion that often follows after one's death. And like any good plan, it needs to be updated as your life changes. That's why I've always found it ironic that it's called the last will and testament, when in reality it should be called your latest will and testament. One of the biggest mistake people make is treating their will as something they do once and they forget about it. I always tell my clients to think of their will as a living and breathing document. Your will should evolve as your life does. In other words, as your assets, relationships, and wishes change, your will should also reflect that. This way, when your family needs it, your will can provide them with a clear, up-to-date picture of your intentions, making it easier for them to move forward. So, who should make a will? The simple answer, everyone. The only legal requirements for making a will are that you, 1, must be an adult, meaning above the age of 18, 2, must be of a sound mind, 3, must be signed by you in presence of 2 witnesses, and 4, you must be acting on your own consent or free will. This only means that you need to understand the implications of creating a will, and you should not be under any pressure or undue influence from someone who might benefit from it. As I said, most people associate making their will with death, but I think a more appropriate term is legacy. Legacies aren't just for the wealthy or the elderly. They come in all shapes and sizes. Whether you have a large asset base or just a few cherished possessions, your legacy is whatever you leave behind for those who you care about. In today's world, nearly everyone has at least a bank account or some form of financial assets. If nothing else, creating a will spares your family the unnecessary burden of navigating the legal system to access what's rightfully theirs. So we have covered what a will is, who should create one, and why it's crucial for safeguarding your legacy. But what happens if you don't have a will? This brings us to the concept of intestate death, a situation no one wants to leave their loved ones in. When someone dies intestate, that is without a will, the law steps in to determine how their assets should be distributed. And this process is not as straightforward as you might think. In India, unlike other countries, intestate succession laws vary depending on religion, gender, and the type of assets involved. This can lead to complicated legal battles, lengthy court procedures, and perhaps most importantly, outcomes that may not align with your wishes. At this point, you might be wondering what this exactly means. Let me explain how these laws differ for various religious communities. For Hindus, Buddhists, Jains, and Sikhs who die without making a will, the Hindu Succession Act, which was first enacted in 1956, comes into effect. This law decides who gets what from your estate, starting with your closest relatives like your spouse, kids, and parents. This is a good example of differing rules based on gender. For example, for a Hindu man, their estates are split equally among their class 1 heirs, which is spouse, children, and mother. On the other hand, if a Hindu woman passes away without a will, her assets first go to her husband and children, but if they are not around, the law could direct her assets to go to her in-laws even before it goes to her own parents. Unfortunately, this reflects the ongoing gender biases in Indian succession laws, and although an amendment in 2005 gave women equal co-partnership rights, the gender gap still remains painfully evident. Similarly, for Christians, Parsis, and Jews, their estate falls under the Indian Succession Act of 1925. Although this law has undergone several amendments, it still largely reflects the legal thinking of nearly a century ago. The fact that it hasn't undergone significant changes since then raises concerns about its relevance in today's context, especially considering the evolving nature of the family dynamics and asset ownership in today's India. And finally, for the Muslims in India, estate distribution is governed by the Muslim personal laws, also known as the Sharia law, rather than a single codified statute like the Hindu Succession Act or the Indian Succession Act. This means that the rules for dividing a Muslim estate after their death are based on religious texts and principles. The key thing to know here is that the Muslim inheritance laws are quite detailed and specific, with fixed shares for certain relatives like parents, spouses, and children. So for instance, under the Sharia law, a Muslim man's estate would typically be divided so that his sons receives twice the share of his daughters and his wife would receive approximately 1/8 of his estate if there are children. Unlike other religions where making a will can significantly alter the distribution of assets, in Muslim law, a person can only will away up to 1/3 of their estate, with the rest being distributed according to these predefined shares. This makes it especially important for Muslims to be aware of the limitations and plan accordingly to ensure their estate is handled in a way that aligns with their wishes while staying within the bounds of their religious laws. It's a unique system and one that really highlights the importance of understanding how different laws apply depending on your faith. I want to quickly highlight a case that recently came our way. The client needed to obtain a succession certificate in order to claim his father's mutual funds that were approximately 23 lakhs. Unfortunately, he had to pay court fees of 1.2 lakhs, and this did not include even professional fees. It also took him approximately 6 months to finally get this succession certificate. All this hassle and cost could have been easily avoided if his father had written a will. So now you should have a clear understanding of the intestate succession rules in India. And if it's still a bit confusing, I don't blame you. These laws can be complex. But if you take away one thing from this masterclass, let it be this. Make your will. A will allows you to bypass all these intricate laws because it takes precedence over your intestate succession. By doing so, you ensure that your wishes are followed and your loved ones avoid any unnecessary legal complications. So how to make your will? Before I dive in, I would like to take a minute to explain that while a will is a powerful tool for distributing your assets and naming guardian for your minor children, it does have its limitations. A will is ideal for straightforward instructions on who should inherit your property and who should take care of your children. However, it can't handle more complex scenarios like setting a condition on inheritance. Say for instance, requiring your children to reach a certain age bracket or accomplish a specific goal before receiving their inheritance. For that kind of detailed planning, you would need to set up a trust, which we will cover in the subsequent chapter. Okay, with that out of the way, let's talk about some specifics for how to create your will. First things first, take inventory of your assets. This means listing everything you own, from real estate and bank accounts to personal belongings like jewelry or artwork. It's crucial to have a clear understanding of what you're passing on to your loved ones. Next, decide who your beneficiaries will be. These are the people or organization who will inherit your assets. Be as specific as possible to avoid any confusion or disputes later on. Once you have done that, it's time to appoint an executor. This is the person who will be responsible for carrying out the instructions in your will. Choose someone who you trust to handle this important task. If you have minor children, you'll also need to name a guardian. This is someone who will take care of your children if something happens to you while they are still minor. That is, they are under the age of 18. As parents, it becomes our moral responsibility to carry out this task. We have seen young parents collapse during COVID and grandparents on either side of the family fighting court battles for custody of children. But as parents, you know what's best for your child and who would be the most compatible custodian for them when you're not around. After that, it's time to draft your will. Now, many people are under the impression that the only way to create a valid will is by sitting down in a lawyer's office. However, as someone who has been involved in estate planning for almost 20 years, I can definitely tell you that most lawyers are not expert in inheritance law. A will is a legal document, and while a lawyer can definitely draft it for you, it's a bit like needing heart surgery. I know it's a stretch, but go with me on this. If you were in need of heart surgery, would you go to a general surgeon or would you seek out a cardio surgeon? Similarly, when it comes to drafting your will, you want to consult with someone who is truly an expert in this field. This is where Yellow comes in. We started this company because we realized that estate planning wasn't just by signing it in the presence of two witnesses, as required under the Indian, making it much easier to update as your life changes. Many of my clients have mentioned that the idea of sitting in a lawyer's office was a major reason they delayed this important task. With Yellow, that barrier is fully removed, making the process simpler and much more accessible. Once your will is drafted, it's important to make it legally valid by signing it in the presence of two witnesses, as required under the Indian law. Without this step, the will could be considered invalid, potentially leading to disputes or challenges in court. Finally, store your will in a safe place and make sure your executor knows where to find it. You may also want to consider registering your will at a local registrar for added peace of mind, which we also discussed in the previous chapter. And that's really all it takes. Despite common misconceptions, making a will is actually quite straightforward. But don't go anywhere just yet. I'll soon share some valuable insights, pitfalls to avoid, and tips to ensure your will is as strong as it can be. As an estate planning expert, I've seen firsthand how poorly drafted wills can lead to unnecessary complications for families. To ensure your will is robust and leaves no room for ambiguity, here are my top tips. 1. Be detailed with your asset inventory. Make sure to provide a comprehensive list of your assets. You don't need to include the assets' values, but it's important to make sure the assets are easily identifiable. Include descriptions, photos, and any relevant documentation if you have them. So let me give you a basic example. If I have to capture my bank accounts, I would simply mention my bank name, branch, and my account number. So that would be HDFC Bank, Richmond Road, Bangalore, account number XYZ123. For more details and to avoid ambiguity for my next of kin, I would even give a photograph of my checkbook. Similarly, for properties, I would simply mention the type of the property and the address, like residential property located in 1 MG Road, Bangalore. If you have a banking relationship manager or even a financial advisor, include their contact details so your family knows who to get in touch with when the time comes. With Yellow, you can easily and systematically add in your asset details, upload photographs, financial statements, add in notes, and edit or update your will as you wish and at any point in time. 2. Keep your nominations updated. Ensure that you have added your nominations for all your financial assets and that these nominations are current. Aligning these with what is stated in your will make the whole process of accessing these assets much smoother for your family. This step also avoids any discrepancies between your will and the records held by the financial institutions. 3. Appoint a trusted and willing executor. Always name an executor in your will. Have seen situations where no executor was named, and this led to unnecessary delays and confusions for the families, creating a need to approach courts. It's crucial to choose someone you trust, and you should ensure that they're willing to take on this role and responsibility. For nuclear families, where your wishes are to pass on all assets to your spouse, then he or she can just be your executor. However, if you have more complex wishes, then you may want to consider appointing an independent executor to avoid any sort of conflicts. And ideally, your executor should be younger than you to increase the likelihood that they will outlive you. And they should also be local, living close to where the majority of your assets are held. This proximity can make a big difference in efficiently managing your estate. Remember, the executor plays a very crucial role in your will, not only to ensure your wishes are given effect to, but also to make sure that all your final statutory compliance are completed, such as filing your income tax return, surrendering your PAN, passport, so on and so forth. So please appoint someone who you trust and, more importantly, who will stand up for your family when the time comes. 4. Decide who your witnesses will be. Like with an executor, choose 2 trustworthy witnesses who you know will be there for your family when the time comes. Unlike other generic documents, we do not suggest using house helps, drivers, etc. as they are not permanent people in your life. The reason I'm saying this is because if the will gets contested, they will be required to be present in court to testify that they witnessed you sign your will in their presence. Again, even here I've seen situations where witnesses do not show up when they are required. So be sure to think this through completely. 5. Register your will if it includes property. While registering a will is not mandatory under Indian laws, it is highly advisable when your will includes real estate assets. This is because a registered will makes the whole process of asset transfer, especially for real estate assets, much simpler and faster as compared to an unregistered will. Having a registered will can simplify and expedite the process of transferring property titles, as it's seen as more authoritative and trustworthy. And beneficiaries will face fewer obstacles when dealing with government authorities and financial institutions if the will is registered. Registering a will in a way makes the government act as a witness to your will in addition to your 2 witnesses. And further, in case the original will is lost, you can always approach the sub-registrar to retrieve this certified copy, which is equivalent to an original will. 6. Video record the signing of your will. Consider doing this as it acts as an additional layer of security, providing a clear evidence of your intent and state of mind when the will was signed, which can help your family if your will ever gets challenged. The Supreme Court in many instances have accepted this as a valid proof. This activity does not need any kind of professional setup. All that you need is a smartphone to record yourself reading your will. Just make sure you read out the contents of your will all in one go without stitching multiple takes and videos together. Don't worry about mistakes or fumbling on words while reading. What matters is continuity. Your witnesses don't need to be in the same room while you read your will on camera. You can call them in when you're ready to sign your will and get their signatures as well. Once again, I want to stress that the recording should all be in one single take. Now on to number 7. Get a medical certificate. Consider obtaining a medical certificate from your physician to attest your state of mind, especially if you're elderly or concerned about somebody contesting your will. This can provide additional evidence that you were of sound mind when making your will, adding a layer of protection against potential disputes, if any. It is important to note here that it is preferable to get this on the date of signing the will, not a day earlier or later. 8. Create a separate will for assets in India. If you hold assets in multi-jurisdictions, it's a good practice to create a specific will for Indian assets. As I've mentioned, the rules can vary significantly across different jurisdictions, and Indian succession laws are particularly complex. Having a separate will for your Indian assets simplifies the process and ensures that your wishes are followed according to Indian law and offer the benefit of quick and smoother asset transfer process. Typically, if an overseas will needs to be executed in India, it will require your family to obtain probate in the jurisdiction where the will was first written, and then again in India before any kind of transfer can happen. This can delay the whole process by months or even years. Having a separate will can ensure the transfer process runs parallelly in each country, saving time and, more importantly, cost. And finally, 9. Talk to your family about your will. In India, cultural superstitions can sometimes prevent families from having discussions on topics like wills and estate planning. However, I always urge my clients to overcome this hesitation. Make sure family is fully aware of your wishes and the existence of your will. What's the point of going through the whole motions of creating a will if your family is not aware of its existence? This transparency will make it easier for them to honor your intentions and reduce any potential disputes or confusions later on. Recently, we spoke to a client who ran from pillar to post and took years to recover assets of his deceased father, and in the final stages of this entire activity realized the existence of a will. Had he known earlier, he and his family would have not gone through so much pain and hassle. I'm well aware that this conversation can sometimes be difficult. I also know that sometimes family dynamics do not allow for such open conversations. So if this is the case, then you should at least inform your executor to let him or her know the existence of your will. As we wrap up this chapter on wills, remember that estate planning isn't just about checking a box or filling out a form. It's about ensuring that your legacy is protected and that your loved ones are cared for in the way you intend. A well-drafted will can be the difference between a smooth transition for your family and a prolonged, stressful ordeal. In the next chapter, we will go into more detail on the topic of trust, another powerful tool in your estate planning toolkit. Trust can offer more control, flexibility, and protection for your assets, especially if you have more complex needs or specific goals for your estate. Stay tuned as we explore how trust can complement your will and provide even greater peace of mind.